just dealing then with my next grounds, which of course apply only if the court's not with me on the first ground, the judicial immunity point at common law. The second grounds, as I touched upon before we rose, concerns the impact of the Equality Act, if indeed the Equality Act confers on police officers a right to bring proceedings in respect of a dismissal, even where that is affected by a police panel, hearing panel, misconduct panel, then that's the end of it. It doesn't matter what the common law says. They have that right, Parliament's conferred it. It is the respondent's case now, as I understand it, that there is not a right under the Equality Act because the members of the misconduct panel, if I've understood their case correctly after this morning, are not acting as employees or agents of the chief officer. Or the chief officer as employer, and therefore liability can't attach under section 109. As I've said already, this is a new point. The case has proceeded on the basis that the right exists. And just to remind your ladyship and your lordship that Lord Justice Laws, at the end of his judgment at paragraph 24, makes precisely that point. There is a tension here, he says, or to that effect, because Heath says this panel is immune and Parliament says they've got a right. So I bear that in mind. If you will. But as to the agency employee point, it's now accepted that officers are employees so that section 109, the vicarious liability provision, attaches. We say that when officers are performing their role as panel members under the misconduct regulations, they are acting as employees. Is within the broad meaning that must be given that concept, given that it applies to police officers. That is apparent because they are performing functions as a police officer, and indeed they are performing it under the direction of the chief officer, their chief officer, for the avoidance of doubt. And we know that because Regulation 25 tells us, so Volume 1 of the Authorities, Tab 5, we've already looked at this, but just to remind your lordships and your ladyship, MS 209, Regulation 25, 209, towards the bottom of the page, persons conducting misconduct proceedings, officers that are other than senior officers, and then moving down, so that's misconduct meeting, and then over the page, subparagraph 4, where the case is referred to a misconduct hearing, that shall be conducted by a panel of 3 persons appointed by the Commissioner. That will be the person, the Commissioner, under whose direction and control the police officer sitting on the panel will be. And it is self-evident, therefore, that the officer is acting within the terms of his office or in the course of his employment, as it's put in the Equality Act. So if Section 109 applies, and we say it does, and that's accepted, then there's no issue. Vicarious liability attaches. As to the non-police officer members, they will either be employees, there'll be no issue about that, there'll be a human resources professional, perhaps from the Met Police, or there'll be agents. They're appointed by the chief officer to perform the functions under the regulations, that is to assess compliance with the standards of conduct and determine sanctions. So my submission there is no point now under section 42, or at least that I can deduce. If I have to come back to it in reply, I will. But that concession in relation to section 109 being made, the position is clear. Parliament's conferred the right, the common law is displaced as a matter of necessary implication. And that's where it is.
If there's vicarious liability, is there also by definition personal liability on the individuals?
There is under section 109, yes.
So not just the police officers, but also anybody else?
Well, it will be the panel members. I'll just remind myself of the precise section. I think it's not in 109. It's in
It won't be
110, so it's 137. Yes, the Equality Act operates differently in this respect than as compared to other employment legislation. So MS 137, section 110, liability of employees and agents, and in essence, if an employer or principal is made vicariously liable for a discriminatory act of his employee or agent, that employee and agent is jointly liable, or can be jointly liable. In practice, it's unusual to sue the individual. It does happen when they're senior, certainly happens when they're senior, but it's unusual. It's normally one's wanting the remedy from the employer, but yes.
I'm just thinking aloud, Ms. Monaghan. What I'm thinking is that 109 applies to anything done by a person in the course of that person's employment, a person A. Now, here we're dealing with something which is done by a panel of 3 persons, 2 of whom in the present case are can be regarded as employees of the commissioner, and a third of whom can't, I think, right? And so you have to say that the decision of the action taken by the panel collectively amounts to something done by the individual officers on the panel in the course of their employment.
Yes, as I've indicated in our submission, the third member, the non-officer, would in any event be an agent.
Under subsection 2.
Yeah, so would be an agent in any event. But just dealing with the panel point, that is, are they as one when they're constituted as a panel? Certainly in discrimination law terms, the fact that there are 3 or 5 people collectively making a decision doesn't mean that a claim of discrimination can't be brought as against one or other of them individually, as well perhaps as collectively, if a prohibited ground was one of the causal reasons for the adverse treatment. It need not be the only reason, it needs only be one of them. So in other words, the decision need only be infected by the discriminatory animus, if I can put it like that, of the other panel members. But typically in a disciplinary context, one will sue the disciplinary panel and contend that they were all, or one or other of them, coming to their decision on a discriminatory basis.
The difficulty I have with the agency analysis is that the action taken by the panel can only be taken by the panel. It's not something which the commissioner could do himself under the legislation.
Well, no, but they are directed by the commissioner to perform functions that presumably otherwise, absent this regulatory scheme, he would be the one to carry out.
I see.
They are carrying them out they're carrying them out under the direction of the officer. The third panel member, the non-police officer, is less easy because one's constructing an agency relationship, but in my submission still falls comfortably within that concept. The 2 officers, or the 1 and or 2 officers, most certainly fall within section 109, bearing in mind the concession made. And so my submission, that doesn't cause any difficulty.
But the officers, both the officers, and I'm looking at Regulation 25.4, and we've looked at the definition sections. If necessary, we can go back to them. But neither the officers nor the human resources professional need be from the force in question, need they? I mean, these were, as I understand it, and it may be that very often, or even generally, they are, but they certainly don't have to be. It could be any force.
Well, they would be acting as agents in that context, appointed by the Chief Constable.
Well, they're nominated by him or appointed by him, but are they his agents?
Appointed by him to carry out functions in relation to officers that are under his direction and control.
Certainly.
We would say yes, performing functions which concern the maintenance of the police force and which would otherwise have to be discharged by him or the police authority.
Well, no, he couldn't, could he? That's the
Well,
trouble.
he can't under the regulations because there is a body,
Anyway,
a body
that's
to
the
whom that
argument.
function is delegated in consequence of the statutory scheme.
But they're acting qua police officers in any event, aren't they?
I beg your pardon?
They're acting qua police officers.
Yes, yes.
I mean, they're there by dint of their position as police officers, and therefore, you would say, in the course of their quasi-employment.
Yes. I think the point my Lord Hughes was, if I may say so, was if therefore another force, can we sue the Met Commissioner on the basis of vicarious liability?
Yeah.
And if I have your Lordship's...
Well, yes, and your answer is yes, because they're agents.
Yes, because they're
And
agents.
They're, what I at least personally would like to think about is whether they can be agents, as Lord John points out, for something that he couldn't do himself. But that's the question exposed. You've given us your answer.
Yes. There we are. That's perhaps as far as I can go with that, unless there's something I can help with in particular. So we say Parliament's conferred the right, that's displaced the common law. The question whether or not there is a right under the Equality Act is important, of course, not just because if there is, it brings an end to the argument, we say, but secondly, because Article 6 will only be engaged, and Article 47, to the extent that it guarantees the right to access a court, if there is an underlying civil right. So we need a civil right, we can't construct one, but we say it's found in the Equality Act. We also say in relation to Article 6 and Article 47 that not only is there a right under the Equality Act, but even if we were wrong about that, and we say we're not, but even if we're wrong about that, that right exists in EU law, it's directly effective and can be relied on in the employment tribunals through the conduit of the Equality Act. So the way in which directly effective employment-related rights are enforced is by reliance on primary legislation through the employment tribunals. Benkabush, which is coming here in due course, and which is cited soon, is an example. State immunity set aside under Article 47 and Article 6. The claims will proceed to the employment tribunals in reliance on the working time regs, I think they were, and the Equality Act, with the relevant parts set aside or words read in, as the case may be, assuming.
Unless, of course, the appeal is allowed.
I shall say nothing about that. We rely on Benkabush, of course. Article 6 and Article 47, as we say, depends upon there being a justiciable right, but we have one in any event under EU law, if nothing else. Article 47 is directly effective. We know that from Article 6 of the Treaty on the European Union. Don't need to take you to it, but Volume 1, Tab 9, MS 295, accords the Charter of Fundamental Rights the same value as the treaties, a point made in Benkabush, but in any event apparent from the face of the treaty. As to the relevance of the appellant's status as a police officer, you will have seen from the respondent's case that they say Article 6 and Article 47, to the extent that they guarantee access to a court, do not apply because the appellant is a police officer, and the guarantees in Article 6 and Article 47 don't apply to police officers as a group, as a class. That was the position under Pellegrini, but the position has now changed at Strasbourg level. So Eskelinen, Volume 4, Tab 35, MS 1023, and this is all premised, of course, on the fact that my earlier arguments don't succeed, but these aren't. We don't need to succeed on these arguments if we've succeeded on the earlier ones. I hope that's our case. So Eskelinen, it concerned, I don't need to trouble you with the facts, MS 1023, it concerned the payment of certain allowances to police officers and to an administrative member of staff working in the police station in rural areas. It was said that Article 6 wasn't engaged because of case law, which indicated that those working in certain sectors, in particular exercising state powers, in relation to labour disputes, were not entitled to the protection of Article 6 because there was no civil right engaged. It was much more of an administrative law process, exercising functions of the state, Article 6 not engaged. That position was very controversial, produced anomalies and very many other things, and Eskelinen changed the position. If I can ask you please to turn up MS 1039, paragraphs 55 to 6. This is referring to Pellegrin. The court can only conclude that the functional criterion was the criterion used in Pellegrin to determine whether or not Article 6 was engaged in labour disputes concerning public sector workers, and the functional criterion was such that if a person was exercising powers of the state, police officers being a paradigm example, then they were outside Article 6 in relation to their labour disputes. According to the court in Eskelinen, court can only conclude that the functional criterion as applied in practice has not simplified the analysis of the applicability of Article 6 into proceedings to which a civil servant is a party, or brought about a greater degree of certainty in this area as intended. It's a Grand Chamber decision, I should say. It's against this background and for these reasons that the court finds that the functional criterion adopted in Pellegrin must be further developed. Whilst it's in the interests of legal certainty, foreseeability and equality before the law that the court should not depart without good reason from precedents laid down in previous cases, a failure by the court to maintain a dynamic and evolutive approach would risk rendering it a bar to reform or improvement. Pellegrin should be understood against the background of the court's previous case law and constituting a first step. So indicating that things are moving on and this is a progressive development so far as the case law was concerned. And then I won't read you the whole of that section, but if your ladyship and your lordships would just note that at paragraph 60, the court draws on, among other things, Johnston 1041. Johnston is a Court of Justice case, well-known Court of Justice case, female police officer precluded from bringing an employment tribunal because of a national security certificate that was issued, held to be unlawful. She had a right under the directive. So relying on community law, where there's a bar that precludes access, even in the case of police officers, certainly under community law, the Equal Treatment Directive, that's prohibited. Paragraph 62 deals with the state of the law now, so far as the Crown Chamber is concerned, having decided to reflect upon the guidance in Pellegrin. So paragraph 62, to recapitulate,
Recapitulate.
thank you, I'm sorry. Recapitulate, I stayed up too late last night. Recapitulate. In order for the respondent state to be able to rely before the court on the applicant's status as a civil servant, in excluding the protection embodied in Article 6, two conditions must be fulfilled. This applies in relation to the police as anybody else, I interpose. Firstly, the state in its national law must have expressly excluded access to a court for the post or category of staff in question, plainly not here. Secondly, this exclusion must be justified on objective grounds in the state's interest. Nothing here of that sort. The mere fact that the applicant is in a sector or department which participates in the exercise of power conferred by public law is not in itself decisive. In order for the exclusion to be justified, it's not enough for the state to establish the civil servant in question participates in the exercise of public power, or that there exists, to use the words of the court in Pellegrin, a special bond of trust and loyalty. That's not enough between the civil servant and the state as employer. It's also for the state to show that the subject matter of the dispute in issue is related to the exercise of state power, or that it calls into question the special bond. Thus, there can, in principle, be no justification from the exclusion from the guarantees of Article 6 of ordinary labour disputes, such as those relating to salaries, as allowances or similar entitlements, on the basis of the special nature of the relationship between the civil servant and the state in question. There will, in effect, be a presumption that Article 6 applies. It will be for the respondent government to demonstrate, firstly, that a civil servant applicant does not have the right of access to a court under national law, something express, and secondly, the exclusion of the rights is justified. So we say Pellegrin has gone, and there is no reason now why Article 6 should be assumed not to apply to labour-related disputes involving the police, in fact, quite the converse. There is then, we say, a procedural bar in place, assuming your ladyship and your lordships are with me, that there is a substantive right under the Equality Act, and in any event under EU law, then the principle of judicial immunity operates as an impediment to access to a court. In my submission, there can be no real doubt about that. Benker-Bush makes the point, as do all the state immunity cases, but perhaps for a case that's closer insofar as the legislative scheme is concerned, perhaps I could invite your lordships and your ladyship please to turn up volume 4, tab 34, MS 986. What's my bundle? Excuse me, I'm sorry, my lords. Oh, it's the same bundle. Tab 34, Tinnerly. Tinnerly concerned, it's an old case, but the principle remains relatively old, concerned a national security certificate again, so much like Johnston. This was in the Northern Irish context, a claim brought under the Fair Employment Act that prohibited discrimination connected with religion for obvious reasons in the context of Northern Ireland. There was provision under the Fair Employment Act to issue a national security certificate, as there was indeed in the case of Johnston, and a national security certificate was to be treated as determinative of the question whether any adverse treatment was related to national security and thus outside the scope of the Act. We see that at MS 992. This was a public procurement exercise builders essentially refused a contract, said to be because they were Catholic. MS 992, paragraph 18. On 20 October, a senior official made a formal request for the Northern Ireland, the NIE being the respondent, made a formal request to the Secretary of State for Northern Ireland via a civil servant in the Department of Economic Development for the issue of a certificate under Section 42 of the 1976 Act, that's the Fair Employment Act, to the effect that the decision not to grant Tinnerly the contract in question was an act done for the purposes of safeguarding national security or for protecting public safety or public order. Pausing there, I should say that that constituted an absolute defence in a claim of discrimination. That is, if an act was done for the purposes of safeguarding national security. The Secretary of State issued the certificate on the 28th of October 1987. By virtue of 42.2, the certificate was conclusive evidence that the act was done for the stated purpose. So in other words, once that certificate had been issued, it was conclusive proof that the reason for the adverse treatment was national security, and that constituted an absolute bar to a claim under the Act. And then MS 1003-4. You'll see at paragraph 42 and 45 the provisions I've just described. I needn't take you back through them, but that sets out the statutory scheme and summarises what I've said here. And then at at page MS 1014, paragraph 72, the court recalls that Article 6 embodies the right to a court on which the rights of access, that is, the right to institute proceedings before a court in civil matters, constitutes one aspect. It then goes on to say thereafter that, of course, the right's not absolute, may be subject to limitations, and deals with proportionality at the bottom of that paragraph. And then at 73, against the background of this statement of principles of relevance to its consideration of the incident case, the court notes that at no stage of the proceedings was there any independent scrutiny by the fact-finding bodies set up under the Acts of the facts which led the Secretary of State to issue the conclusive certificates under Section 42. Primary fact-finding body, the Fair Employment Agency, could not pursue its investigation into Tinnerly's complaint, nor was it able to determine whether there existed a basis in fact for refusing clearance. As to the latter issue, the agency was obliged, in view of the issue of the Section 42 certificate, to have the proceedings moved to the High Court to seek judicial review, but there was a prohibition on going to the court. So as to the Macdulphs, the Fair Employment Tribunal was never presented with any evidence as to why the complainants were considered a security risk. And 74, court would also observe that judicial review proceedings in the High Court in the Tinnerly case never led to a full scrutiny of the factual basis. Of course, judicial review will be generally an inadequate remedy in this case. And then at paragraph 78, the court notes that in other contexts it's been found possible to modify judicial procedures, etc. And then at 79, a disproportionate interference. So analogous, it's a different form of an absolute bar. There, a national security certificate. Here, a common law bar introduced by the principle of judicial proceedings immunity. But it's a bar, not doesn't affect the presence of a civil right, a substantive right under EU law or domestic law. And if it's going to be lawful, it must be justified as proportionate. And for the reasons already given this morning, we say it's disproportionate. Ben-Carbush I've alluded to. It doesn't seem to me to be necessary to take your ladyship and your lordships through it, since it makes the points I've already made and that I think are largely uncontroversial. That is, that Article 47 is directly effective and must therefore operate to disapply any domestic rule which disproportionately restricts access to a court. The Court of Appeal in Ben-Carbush took a somewhat different view about the approach to state immunity as compared to the Strasbourg Court, but that's not material here. The fact is, it was a bar. Article 47 was directly effective. If it was going to be lawful, it had to be proportionate. For reasons that I've touched upon this morning, and will just be repeating myself if I go back to them, we say any common law immunity in the context of this case is wholly disproportionate, and therefore, to the extent that it hasn't already by the Equality Act, it must be disapplied. I've taken that rather quickly, but I think I've made the arguments I need to, along with the written case, and I'm not sure.
Can I just be sure I've got your argument noted correctly on one point? Clearly, you argue that the decision of the action taken by the disciplinary panel falls within Regulation 42.
Yes.
If you're wrong about that, you say in any event the EU right under the directive is directly effective and can be relied upon. Now, the mechanism for doing that, is that to Marlease, as it were, Regulation 42?
Yes.
That's how you do it?
Yes.
Okay.
And that's how you either disapply in the case of a piece of primary legislation which can't be read down, or you Marleasing it.
Yes. So are you Marleasing the phrase "any act done by the chief officer" to include treat it in order to achieve a conforming interpretation, treat it as covering dismissal by the disciplinary panel?
Yes. And of course, in terms of wording, as your lordship knows, Luxembourg doesn't require us to get too wound up about the precise wording. We don't have to draft the legislation. We just have to read it in a way which is conformable. And this can be easily read in that way. And we say, properly analysed, given the EU background, to be intended, or at least understood, to protect those rights. And that's how they're generally afforded in domestic law. That is the equality directives where provision hasn't already been made through the domestic scheme.
Alternatively, I suppose you could focus on the regulations.
You could accept that the Equality Act is the route by which Parliament's given effect to the equality directives.
Yes.
To choose a different scheme to give effect may cause other problems, since the enforcement mechanisms are all under the Equality Act. So one would have to say, we'll read the regulations in a way which means the Chief Constable is the dismissing officer.
Yes.
We'll then be able to have the vicarious liability provisions under the Equality Act apply, so that the enforcement mechanisms thereunder can apply. And I suppose it's possible.
If he's the dismissing officer, you wouldn't need the vicarious liability, would you?
Precisely.
You'd have Section 42 straight
Precisely.
away.
Yeah.
So it's a convoluted way of doing it, and perhaps the easiest way is just to say, one way or another, these dismissals are caught, as they must be, because of the impact of EU law, and how that's done, we needn't worry about too much.
Yeah. I suppose a point that might be made in light of the question asked by Lord Hughes might be the principle of equivalence would indicate that if you're within the scope of a directive, you should have an equivalent remedy to other people who are covered by the directive, which would take you to Part 5 of
Precisely the point I was making to Lord Hughes, that it would have to, the enforcement mechanism would be through the Equality Act. Yes. And there is case law, both domestically, which holds that judicial review, for example, is an inadequate remedy where a remedy for discrimination is sought. And there is, as I suspect my Lord Reid was referring to, there's jurisprudence from Luxembourg which indicates that where there is a specialist tribunal established, for example, to hear discrimination claims, in fact it was a different context, but discrimination claims, then the right must be enforceable through that specialist tribunal. It's not enough to say, well, sorry, you're not covered by the specialist legislation giving effect to the Equality Act, but you can rush off to the High Court and seek a remedy there. So we say the Equality Act is the easiest way through it, putting it shortly. The last point, I realise I've taken this fairly quickly, but there is a good degree of
Plenty
overlap.
of time left, so
I have got plenty of time left.
Don't feel that you have to use it all.
No, well, I don't. I think I'm
Well,
so
Mr.
used
Lindsay
to.
might want you to use it all.
I'm so used to rushing up against the timetable that I don't want you to be concerned that I'm not taking it carefully enough. But I don't want to repeat things I've already said. So we say Article 47, Article 6 apply. The common law principle of immunity must be disapplied. There's an EU right, and to give effect to that, the Equality Act must be read conformably so as to afford a right in relation to a dismissal. The reading of the Equality Act conformably we dealt with under our fourth ground, which is essentially judicial control and effective remedy, which derives directly from the EU directives themselves, which are directly effective. See, for example, Johnston, which I took you to when looking at Tinnerly. So they are the same points differently framed, but there is both the right to access a court under Article 47 and Article 6, and then to effective judicial control and an effective remedy under the directives, which achieve the same result. That is, there must be access to a court and an appropriate remedy.
If you're right on this second basis, and the judicial immunity which the panel would otherwise have is displaced, is it displaced only to the extent that it is necessary to give effect to Section 42?
Only to the extent that it's necessary to give effect to EU law.
Well, and Section 42. In other words, what I'm let me not broaden it unnecessarily. Is it displaced only to the extent that it is necessary to enable her to make the application to the employment tribunal?
As opposed to?
Well, as opposed, for example, to bringing personal actions against the members of the panel.
They would be entitled, she would be entitled to bring claims against the members of the panel. And the reason for
in the employment tribunal.
In the employment tribunal, in my submission, right. And the reason for that is because of the principle of equivalence. Right. So the
what about suing them for, shall we say, defamation?
It would not be necessary to displace the immunity. I can't promise I know every single EU law, but I'm not aware of an EU law which would confer a right to defamation proceedings.
Would go only to the extent that it is necessary to preserve access to the employment tribunal in relation to discrimination.
Yes.
Is that right?
It is only necessary to give effect to EU law, which in practice, I can't think of anything else, which in practice is likely to be to access a tribunal, to enforce employment tribunal, to enforce the rights that ordinarily apply under the Equality Act.
Thank you very much.
I have finished early, unusually, but unless there's anything I can particularly assist you with at the moment, it may be I'll have to come back to Section 42 if I've misunderstood the arguments.
We'll see what Mr. Linden has to say about that.
Otherwise, those are my submissions, my lady, my lords.
Thank you very much, Ms. Monaghan. Mr. Kemp? I think you're coming next, aren't you, Mr.
Thank you, my lady.
Yes.
My lady, my lords, I appear for the Commission. The Commission didn't apply to intervene on ground one, and so we have nothing that we wish to add to those submissions made by my learned friend. But for the avoidance of doubt, we're not saying that there is a common law right of immunity. We're just not intervening in that issue. As far as grounds 3 and 4 are concerned, we have nothing to add to the appellant's submissions. We agree with those. We did intervene on those. So our submissions are limited to the orthodox common law, domestic law position. We say if you reject ground one and there is there is an immunity for judicial immunity, then it is displaced by Section 42 of the Equality Act. And we advanced the three submissions that we set out in our case. Firstly, that the common law immunity, although not expressly displaced, is displaced by necessary or proper implication. And we agree with the point made by my Lord Hughes that that displacement would therefore only be to such extent as necessary to comply with Section 42 to enable claims to be brought under the Equality Act. And in that context, we're going to focus on orthodox principles of statutory interpretation, but we're going to look particularly at the enacting history, the presumption against an absurd construction, which we say arises on the respondent's construction, and the principle of legality in the specific context of the common law right of equality, which we say now has that status. Secondly, we will submit that if it's correct that the common law immunity has been displaced, then one comes to the question, well, what do you do about that? Because Section 42 doesn't contain the wording that would be necessary, expressly anyway, to allow a claim to be brought where the operative decision to dismiss is taken by the panel. Now, we don't have anything to add to what my learned friend Ms. Monaghan says, and of course, if she's right, if Section 109 does the heavy lifting, then you don't need to read in any words into Section 42. But we respectfully submit that if you don't accept that the panel is acting either in an employment capacity or in a relationship of agent and principal when making decisions under the regulations, it is possible to read in the necessary words into Section 42, applying orthodox canons of statutory interpretation, particularly the Inco-Europe test. So, my lords, looking then at the common law position, and just for your lordship's notes, this is in our written case starting at paragraph 12. While we concede that the Equality Act doesn't expressly disapply the judicial immunity, it's not necessary by reference to principles of necessary or proper implication. And my lords, I'm just going to give you the references in the cases that we rely on without taking you to them. But Bennion, Section 172 and Section 174, that's tab 36 of Volume 4, memory stick page 1058. Then the Child Poverty Action Group case, Volume 8, tab 97, memory stick 2281 at page 2298, and it's paragraph 34 in the judgment of Lord Dyson. And then McCarthy and Stone Developments Limited, that is Volume 10, tab 127, memory stick 3057 at page 3079, and it's at page 70H of the internal numbering of the case. And we respectfully submit that that test of necessary implication is met. And one reaches that conclusion applying ordinary principles of statutory interpretation. And these are set out in our case. Again, paragraph 12. Firstly, we respectfully submit that the overriding objective of the court in interpreting the legislation is to ensure Parliament's intention is met, adopting a purposive construction. And in support of that submission, we refer to the Spath-Holm case. Again, I won't take your lordships to this, it'll all be very familiar, but it's Lord Nichols' speech at page 396F to 397B, volume 12, tab 149, and that's memory stick 3766 at page 3813. my Lord Reed's speech in the UBS AG and the Revenue and Customs Commissioners, that's particularly at paragraph 61, volume 12, tab 150, memory stick 3832 at page 3850. And we respectfully submit that only if it's plain on the plain or literal meaning, it is abundantly clear that some other interpretation should be reached. The court should strive to adopt an interpretation which is consistent with the purpose of the provision. And we respectfully rely upon what Lord Justice Peter Gibson said in the Liversidge case as to the purpose of the legislation with which you're concerned. And I wonder if I might ask you to take up volume 8, tab 96, and then turn up paragraph 31 of Peter Gibson LJ's judgment in that case. It's internal numbering 2269. Where he said that this was in the context of the construction of the 1976 Race Relations Act. He said, "For my part, I have no difficulty in accepting that a statute like the 1976 Act should be construed purposively, provided that is understood what it properly means." And a few lines further down, just above E, discrimination acts are intended to deter and combat discrimination, but it's important not to lose sight of the fact that such acts are not intended to be completely comprehensive in the sense of making all discrimination unlawful. And then just above F, what a purposive construction does allow the court to do is to construe a provision which permits of two possible meanings in a way which gives effect to the identified purpose. And what we respectfully submit is that demonstrates without, as if it could be in doubt, what the underlying purpose of the Equality Act is, that unless you're satisfied that there is only one meaning that can be given to section 42, i.e. that it preserves somehow the existence of a common law immunity, then you must construe it in a purposive fashion to support the underlying function of the Equality Act, which is to allow for discrimination claims to be brought on grounds of disability materially for our purposes. The second principle upon which we respectfully rely is the relevance of the enacting history in determining what the purpose, the underlying intention of Parliament is. For my Lord's notes, we rely on the Bennion passage at section 202, volume 4 of the Authorities, tab 36, memory stick page 1074, and Lord Nichols again in Spath Holm at memory stick 3814, page 397, C to D. And what we submit in the present context is that the legislative history of section 42, namely its predecessor provisions under the Race Relations Act and the Sex Discrimination Act, is critical to a proper understanding of section 42, which was intended to consolidate equivalent provisions in that predecessor legislation. And one sees that particularly in the explanatory note to section 42. I'm afraid this particular part of the explanatory notes isn't in your bundle, but it is set out in full in the written case of the respondent, which your lordships will find at memory stick page 5036 in the respondent's written case at paragraph 66.
Was it technically a consolidation, the Equality Act?
I beg your pardon, my lady?
Was the Equality Act technically a consolidation? I don't think it was.
No, but in relation to this particular provision, this particular provision was intended to replicate the previous provisions.
Well, most of it was intended to replicate or harmonise or generally make coherent the previous patchwork of provisions, wasn't it?
Yes.
But it wasn't exactly just bringing them all together and restating them.
No, but for the purposes of the principle of statutory construction, that a consolidating act or a consolidating provision should generally be read, provided it's in pari materia with its previous incarnation, we respectfully submit that it is sufficiently similar, section 42 is sufficiently similar to the predecessor provisions, that it should be given an interpretation which is in harmony with those provisions. But one sees there at paragraph 66, this section is designed to replicate the provisions in previous legislation and then extends coverage.
Did the provisions in the preceding legislation
Say the same thing.
say something clearer?
No, they said essentially the same thing. Apart from, interestingly, the Race Relations Act 1968. But the Race Relations Act 1976 and the SDA, Sex Discrimination Act, and the Disability Discrimination Act all refer to acts of the Chief Constable and acts of the appropriate authority. And I'll take your lordships to them in just a moment. but for the purposes of the principle, we rely upon the principle that the enacting history is relevant and that you should construe Section 42 in harmony with those previous provisions. We also rely upon the statutory presumption against an absurd construction. For your note, again, I don't need to take you to the authorities. Spath Holm, Lord Nichols at page 397F to 398C, volume 12, tab 149, memory stick 3814 to 5. Shaheed against Scottish ministers, my Lord Reed's speech, in particular paragraph 21, volume 12, tab 145, memory stick 3658 at page 3674. And then the Bennion judgment, the Bennion on statutory interpretation, sections 312, in fact, all of those sections in that part of the book, 312 to 316, there's volume 4, tab 36, beginning at memory stick, page 1126. And then the last principle of statutory construction upon which we rely is the principle of legality, the presumption that a provision should not be given a meaning that defeats fundamental common law rights. And I'll come in a moment to explain why, how one applies that in the present context where there is effectively a two competing or more than one competing common law principle that need to be taken into account when you apply the principle of legality. But for the straightforward principles, again, very familiar, but I'll give your lordships the references. Bennion, section 271, volume 4, tab 36, memory stick 1104. Ex parte Pearson, that's volume 11, tab 138, 573G in the speech of Lord Brown Wilkinson. That's memory stick 3442. Again at 575B to G in Lord Brown Wilkinson's speech, memory stick 3444. And then Lord Staines's speech beginning at 587H, memory stick 3457. And then the Sims case, ex parte Sims, Lord Staines's speech, section, page 131D to G, volume 12, tab 146, memory stick 3707, and many, many other authorities, some of which we've referred to in our case, perhaps most recently or significantly the Ahmed and HM Treasury case. And we've also referred to the speech of the Lord Chief Justice Thomas in the Miller case, where he says, and this is set out in our case, paragraph 18.5, unfortunately the judgment didn't make it into the bundle, where he said this, that all these presumptions can be overridden by Parliament if it so chooses, but the stronger the constitutional principle, the stronger the presumption that Parliament did not intend to override it, and the stronger the material required in terms of express language or clear necessary implication. And what we respectfully submit is that shows there's a balance to be struck when one applies the principle of legality. We would go so far as to say that the exercise is one of proportionality when one is balancing differing public interests and private rights. So, my Lord, those are the principles on which we rely. The submissions that we make in relation to necessary or proper implication are set out in our written case at paragraph 20 and following. We say for 4 reasons you must read section 42 as impliedly displacing the common law immunity from suit if it does indeed exist. Firstly, because it's inconsistent with the enacting history. Secondly, because of the anomalies that arise. Thirdly, because the respondent's interpretation defeats fundamental common law rights. And fourthly, because there are no alternative remedies for the resulting injustice. As to the enacting history of Section 42, by reference to the Equality Framework Directive, we adopt what we say at paragraphs 27 to 29 of our written case. I'm not going to develop that.
When you say there are no alternative remedies for the resulting injustice,
Yes.
what do you say about the facility for an appeal to the tribunal on the basis that the dismissal was wrong because it was infected by relevant unfairness?
Yes. Well, we adopt what
But what you say?
Well, what we say is that that is not a remedy for unlawful discrimination. If there's been unlawful discrimination, then there should be a remedy for that unlawful discrimination, for example.
But when you're saying to an appeal tribunal, I was discriminated against in the decision to dismiss,
Yes.
why isn't that a remedy referable to discrimination?
Because if it is found that there has been discrimination, there's, among other things, no power in the tribunal to order a compensatory award for the injury to feelings that ensues as being caused as a result of an act of discrimination. So while they may have the power to provide some remedies, they don't have the power to provide the necessary remedies that that are provided for under the Equality Act.
But also the directive. It would be a failure to implement the directive
Indeed.
if there was no means of sanctions being imposed.
Exactly. Now, my Lords, of course, my submissions at the moment are proceeding entirely down the orthodox domestic law track. If it's taken as read that everything I say about the domestic law, we respectfully submit is reinforced by the EU law position. But we submit consistent with the speeches of your Lordships, for example, Lord Reid in Osborne, that if you can find a route through this applying the domestic law, then that should be your first port of call. So we turn then, my Lords, to the enacting history of Section 42 by reference.
I'm not sure that my Lord would necessarily say that about EU law.
Yes.
Directly effective EU law as opposed to human rights.
Well,
Yes, I share her ladyship's doubts about what I might say.
I was trying to interpret his facial expression. Not always a good idea.
I'm not going to try that, my lady. My lady, my lords,
But if Article 17 of a directive requires there to be provision for sanctions in domestic law.
yes,
Yeah. And for that matter, Article 3 extends the scope of a directive beyond employers, but to any person in relation to dismissals.
yes, and as my learned friend has pointed out, there's no exceptions made in relation to police officers as to the applicability of any of those directives, but specifically the framework directive in relation to disability. My lady, my lord, should have a note that the Commission filed yesterday with a table that's attached, and I'm just going to take you through that, if I can, relatively quickly, just to make good our point. But what we respectfully submit is this. At the moment, the difficulty that's caused by the application of Section 42 in the context of a non-senior officer is that the decision to dismiss is taken by a panel. However, what is clear when one looks at the enacting history is that that was not always the case. And so if one turns up the table, and one can see that under the Police Discipline Regulations 1965, the final decision on dismissal was always taken by the Chief Constable for non-senior officers, and for senior officers by the police authority. And so when the 1975 Sex Discrimination Act was introduced, and when the 1976 Race Relations Act was introduced, which made equivalent provision to Section 42 by reference to the acts of the Chief Constable being deemed to be subject to the employment provisions, or the police authority. Those provisions were introduced in the context of a procedure where the decision to dismiss was taken by either the Chief Constable or by the police authority. So when one seeks to understand why it was that the draftsman in well, if we just perhaps turn up the Sex Discrimination Act, Section 17, you'll find it in your Authorities Bundle, Volume 5, at tab 39. And it's memory stick page 1159. And one can see wording that is remarkably similar to that. It's now found itself in section 42. For the purposes of this part, the holding of the office of constable should be treated as employment by the chief officer of police with respect to any act done by him in relation to a constable or that office, by the police authority with respect to any act done by them in relation to a constable or that office. And then if I just take you to the police discipline regulations to make good my point about how the system worked, if I could ask you to turn up again, volume 5, tab 51. This was in the context of police constables. In those days, there were separate regulations for senior officers as opposed to constables. What we now have is one set of regulations for both, but making separate and subtly different provision for each of them. But if you turn to Regulation 12, at page 1258, memory stick, of the memory stick, under Decision of Chief Constable, the Chief Constable concerned at the conclusion of the hearing or where he's remitted the case to some other Chief Constable in accordance with Regulation 16, on receiving the report of that Chief Constable, should decide either to dismiss the case or to impose one of the following punishments, namely, and it included dismissal from the force. And then one finds a similar provision in relation to senior officers, or at least in those days, deputy chief constables.
Those days he would have, of course, heard the case himself, wouldn't he?
He would have sat on the panel.
He would have been the...
He would have been the chair.
He would have been, well, he'd have been usually on his own.
Yes, well, there was provision for him to remit to another chief constable in certain circumstances, but he still took the final decision.
But nevertheless, your point is that because the regulations made it clear that he was the dismissing person...
He was the dismissing body.
It's hardly surprising to find what you do in the Sex Discrimination Act.
Precisely.
Got it.
And one finds the same point in relation to senior officers. If you turn up volume 5, the next authority on tab 52, these were the regulations that applied to senior officers. In the case of senior officers, the decision to dismiss was taken by the police authority. See memory stick page number 1271, regulation 12. And one had a similar situation that the decision of the police authority on receipt of the report of the tribunal, which could make a recommendation, that the police authority shall be either to dismiss the case or to impose, and it included dismissal from the force. So what we respectfully submit is that it made perfect sense in the context of 1975 and 1976 for a provision that deemed a police constable to be employed to refer to acts of the chief constable or acts of the police authority, because generally speaking, the chief constable took decisions in relation to more junior officers and the police authority in relation to more senior officers. And indeed, that system prevailed at least until 1999 in the case of junior officers or non-senior officers, and until 2008 in the case of senior officers. So that's why when one sees introduced in 2003, for example, the provision that eventually became Section 42 as it applies in the case of disability discrimination, the same phrase being used. So if one looks at Volume 6, tab 65, that's memory sick 1493 at page 1518. the curious thing about the Disability Discrimination Act, unlike the Race Relations Act and the Sex Discrimination Act, which deemed police officers to be employed for the purposes of those types of discrimination from the outset, the Disability Discrimination Act 1995 did not include such a provision. It was introduced in 2003. In fact, it came into effect on the 1st of October 2004. You'll find it, Volume 6, Tab 65, and the relevant regulation was Regulation 25, memory stick, page 1518, which introduced, interestingly, under the European Communities Act, because it was intended to bring the Disability Discrimination Act into compliance with the Framework Directive.
Yes, because our Disability Discrimination Act 1996,
95 DDA.
Preceded any EU law prohibiting disability discrimination, didn't it?
Yes, because that came into force in 2000, and the DDA had
And so
foreshadowed it.
this was to
fix
bring
the
us
bit
up to
Yes, to
what the Framework Directive required.
exactly. But one sees the same wording in Section 64A by reference to the chief officer or the police authority. Now, my lords, my lady, I think I've probably made the point, but the fact is that what then happens is that in the case of non-senior officers in 1999, the procedure is introduced whereby the tribunal makes the final decision on dismissal. However, it retains a right in the police constable to request a review by the chief constable. And that's why you get a case like Lake, where the court accepts that there was a jurisdiction because the final decision on dismissal was taken by the chief constable. And that, in relation to non-senior officers, remained the position until 2008. It wasn't until 2008 that the final decision on dismissal was taken by the tribunal for non-senior officers. It had had this hiatus between 1999 and 2008 where there was this right of review. In the case of senior officers, the final decision remained that of the police authority right up until 2008. Now then you get this curious situation between 2008 and 2012, which of course straddles the period during which the Equality Act's introduced. The tribunal is the final decision maker in relation to dismissals for both non-senior and senior officers. But then in 2011, coming into force in 2012, there's an amendment which makes the final decision in relation to senior officers of the Metropolitan Police are now taken by either the chief officer or, in the case of the chief constable, by the local policing board. So you've effectively, by way of the 2011 regulations, reconferred, at least on senior officers, the right to bring discrimination claims. And then, with effect from December 2012, all senior officers have the final decision on dismissal taken by the the local policing board or equivalent authority, which in the case of the Met, of course, is the Mayor's Office on Policing. So what we respectfully submit is two things from that enacting history. Firstly, you have to understand Section 42 in the context of Section 17 of the SDA and Section 16 of the Race Discrimination Act. And they can only be understood in the context of the procedure that was in force at the time that they were enacted. And at that time, the decision was taken by the chief officer or the police authority. Therefore, it must be the case that Parliament intended then that discriminatory dismissals could be sued upon. Now, if that is the case, the consequence of my learned friend's submission for the respondent is that a statutory right has been taken away by a statutory instrument under another enactment, which would, to use the words of Lord Templeman, reverse the result of the Civil War. And secondly, it cannot have been the case that Parliament intended there to be the differences between senior officers and non-senior officers that now exist. Because senior officers, I should point out, still have a right of appeal to the PAT, even though the final decision is taken by the local policing board or equivalent authority. So it's not like they've been given one and then had the other one taken away. They've got both rights. And we respectfully submit that that result is discriminatory. It has no objective justification, and it cannot have been intended. Indeed, we submit that it is irrational. And therefore, it triggers the presumption against an absurd outcome. So that's what we say about the enacting history. Now, I think I can probably deal with the other points on the orthodox construction relatively quickly. But we submit there's more than one anomaly. There's not just this anomaly that senior officers are allowed to sue for discriminatory dismissals. Probationary constables are also able to sue for discriminatory dismissals because, again, in relation to probationers, the decision to dismiss is taken by the chief officer. See Regulation 13 of the Police Regulations, Volume 6, Tab 63, memory stick, page 1414, at page 1440. And indeed, there's a case in your bundle, two cases in your bundle of discrimination claims brought by probationers who have been dismissed on grounds of, that have been brought on the grounds of discrimination. The first one is Hart. It's in your bundle at volume 9, tab 112, memory stick, page 2643. The other one is Hassan, volume 9, tab 113, memory stick, page 2630. And we respectfully submit there's no rational justification for allowing a probationer to bring a discrimination claim, but not a more senior police constable. And the last anomaly we rely on is the fact that that a police officer that has been constructively dismissed can bring a claim. So you've got the situation where under the Act, certain forms of discrimination, discriminatory dismissal can give rise to claims, and there's no rational basis for those that you're able to bring and those that you're not. We also submit that there's something anomalous about the fact that steps preparatory to a dismissal can be sued upon, because steps preparatory to a dismissal are taken by the chief officer. So, for example, the chief officer takes the decision to carry out the investigation. They take the decision to refer the case to a police misconduct panel and the like. Now, each of those are decisions which, in principle, could be sued upon as discriminatory, but the final decision on dismissal can't be. We make the point that if the respondent is correct, it would also mean that it would apply to decisions under the police performance regulations. But we don't ask you to make any decision on that because that's not the case before you, but we respectfully submit that it would create the same kinds of anomalies. And so we submit, paragraph 26 of our case, you must interpret section 42 in such a way that it does not have this absurd outcome. And accordingly, it must be the case that the common law immunity is displaced in relation to decisions to dismiss. I turn then to the issues that we raise under the common law principle of legality.
I think you're already out of time, Mr.
I believe I am, my lady, and I was going to take this very...
You don't get home on what you've already argued. You're unlikely to get home on legality, are you?
I agree, my lady, and what I simply wanted to do was to just draw your lordship's and my lady's attention to the submission that we make. It's our second submission, that Section 42 must be consistent with the common law principle of equality, it doesn't in fact require the court to decide the point, because, as your ladyship has identified, if we don't get home on what we've already identified, then we're not going to get home at all. But the submission that the Commission would like the court to consider is that the time has now come, for the reasons we set out at paragraphs 38 and following of our case, to recognise a fundamental common law principle of equality as a fundamental constitutional principle to which the principle of illegality applies. That is to say, it is no longer to be considered merely an aspect of rationality. Rather, it is to become a lion under the throne, to use the phrase, the memorable phrase of Geoffrey Jowl, QC, in his article, which has been repeated in a number of cases by Lord Hoffman, for example, in Matadine and Pointu, and which my Lady Hale referred to with approval, I think it's fair to say, in one of her seminal articles, which we've also referred to. But I don't think by developing those arguments, I don't think it's necessary to develop those arguments because they're all set out in what we've put in our case and those articles upon which we rely in those cases. And so unless I can be of any further assistance.
No, thank you very much indeed, Mr. Bowen. Thank you.
I just grabbed
Now,
the
Mr.
lectern.
Linden, I hope you're not taken by surprise by the premature requirement to get to your feet.
My lady, I'll cope. Can I start by just what I'm proposing to do is deal with the issues in the order in which they've been presented by. I just wanted to make 5 preliminary points, which are essentially themes underpinning our submissions, and then to turn to the detail of each of the grounds. The first of those 5 themes is to identify clearly the issue in the appeal. That is, we submit whether the chief officer is liable or can be liable for discrimination by members of a panel, disciplinary panel, in performing their statutory functions. I draw attention to that because certainly Mr. Bowen's submissions are presented on the basis that the question is whether a claim can be brought against the chief officer in respect of dismissal. And I accept that the practical consequence at certain stages of this disciplinary procedure of the arguments that we advance would be that a claim for dismissal would fail because the chief officer's answer, for example, would be that the panel made the decision. But as you will have gathered from your reading of the documents, at other points in the history of the procedures, the chief officer did make decisions. For example, a power of review in relation to a decision made by a disciplinary panel. We'll look at the Lake case in due course, where I would accept that the claim could be brought against the chief officer in respect of the decision on the review. At other stages, as Mr. Bowen has developed, the chief officer made the decision where I would submit that the chief officer's decision was subject to judicial proceedings immunity, for example, in 1965, but I'll come back to that submission in due course. So the issue is about whether the chief officer is liable for discrimination by the members of the panel, and as my learned friend Ms. Monaghan correctly accepted, about whether they can be individually, personally liable in respect of those acts of discrimination alleged in brackets. Ms. Monaghan said, well, it's very rare for the individual to be joined to a claim. Of course, she has a great deal of experience in the field, has written various books on the subject, but and of course neither of us can give evidence, but it isn't, you may think, that unusual for tactical reasons, for example, for individuals to be joined. key individuals in a particular organisation, or indeed not simply for tactical reasons, but because the claimant wishes to hold them accountable through the employment tribunal system. So I would invite you not to approach the point on the basis, well, it doesn't matter, because the panel's members will never find themselves as second respondent to the claim.
And particularly if we were with you on your first point, I mean, if we accepted that the chief officer wasn't answerable, then it would be all the more important to know whether the panel members themselves were.
That was my first point by way of a theme or underpinning our submissions. Precisely.
Do I understand that they would be named as members of the panel rather than simply described as the panel, so to speak?
That's right. They would be respondents to the claim and liable, jointly and severally liable with the chief officer in relation to any award of compensation.
Leaving aside the chief officer, the premise on which I asked the question is that instanced by my Lord Reid. If you're right on your first point, then the chief officer drops out of the picture, and therefore, do I understand you to say that it's not at all unusual for individual members of the panel to be named as respondents to claims?
It's not at all unusual for them to be named as second respondents.
Yes.
I can't say to you it's a common event for the individual alone to be named.
I see.
Well, if you've got a vicarious liability situation,
In principle, that's perfectly feasible.
Elsewhere in the law, the actual person, tortfeasor, is responsible. It's just that normally the employer has got the resources and the employer is made to answer it.
Exactly.
But it's by no means, and it's been reinforced in one or two recent cases that the
Exactly right.
employers have brought contribution claims against employees.
Exactly right, my lady. So second thematic point, nor is the issue a remedy versus no remedy at all. The true characterisation of the dispute in our submission is one remedy or two. Because we do submit orally or point out that the claimant in this type of case does have a remedy by way of appeal to the Police Appeals Tribunal and then to the Administrative Court by way of judicial review.
They are, of course, aimed at different things, aren't they? I mean, the appeal is aimed at getting the job back, reversing the dismissal. The discrimination claim isn't aimed at that. It's aimed at getting compensation for the discrimination.
I'm going to have to
That's
deal
not
with...
an answer to your point. It just happens to be true.
Right. Well, I'll definitely have to address that point. And looking ahead, what I'll be pointing out is that in the Marshall case, Marshall number 2, paragraph 25, the European Court said in terms that in a dismissal case, the remedy would be reinstatement or compensation. And you'll have seen in the recitals to the directives that it was said that the sanction may be compensation. So I will be submitting in due course that there is sufficient remedy under the statutory instruments, and in any event that the true characterisation of the argument is as between one remedy, the statutory instruments, or two, the statutory instruments plus the employment tribunal. Third thematic point, addressing, I'll obviously need to deal with the detail of the procedure, try not to worry you too much in doing that. But the observations have come from the court, well, this is just like any other employment case. I paraphrase, of course, but other observations from the court, well, isn't it significant that these individuals are police constables and or office holders, and that there's a particular public interest in the role that they perform? Now, in relation to that, of course, I will be submitting that the nature of the issue under the statutory instruments is materially different, precisely because of the public interest dimension to the decisions that are being made. And I will also be pointing out that that feeds into the recognised by law issue when it comes to deciding whether or not judicial proceedings immunity applied. I'll do that by reference to Lincoln and Daniels in due course. Before I come to my fourth point, though, can I seek to reinforce my broad submission about the public interest by taking you to the Taylor Review, which you have in volume 15, tab 187, MS 4884. Sorry, I've given you wrong.
It's 74670.
Yeah, it's MS 4684 is where I was.
4684 is what you.
4684.
So sorry, I gave you. You've seen referenced both sides seek to draw support from the Taylor Review, which, as you'll have gathered, reported in January 2005, was a precursor to the 2008 regulations, was Monaghan's cases that it led to an increased informality in the procedures and a reduction in judicialisation of the process. We dispute that, as you've seen in our case. But at this point, I just wanted to draw attention to one of the rationales for the recommendations that were being made by Taylor. On page 4684, the uniqueness of policing, the extraordinary powers of police officers and their role in society requires that in the public interest, the disciplinary arrangements of police officers are more appropriately determined by Parliament after extensive consultation. Policing is an area that is too important to be left to the uncertainty of changes to and the case precedent decisions of mainstream employment law. Conduct arrangement must be capable of control and shaping, and this is best achieved by regulation. This will help secure a high level of democratic accountability, drive national consistency, and in the context of complaints by members of the public, ensure the system is citizen-focused. And there is then helpfully summarised a debate that took place in the review as between those who advocated essentially moving to an employment model and those who argued that a model based on statutory regulation should prevail. I'm sure that you and your colleagues, my lady, will take time to read it carefully. But if I can just show you the passages on which I place reliance. Against below 4.2.3, first bullet point, this is the arguments. This is summarising the arguments. The arguments that a highly regulated approach is necessary because of the singular policing environment which puts officers at risk in a routine way not found in other employment situations. That risk derives not only from natural objections by citizens to the exercise of coercive powers, but also because for some of the time, the customers are by definition hostile to the service provider. It's also important to deliver consistency and so on. There's the counter-argument, policing is no different. 4.2.4, in adopting either of these positions, it's generally accepted by all that the concept of the office of constable should be left untouched. It is seen as sacrosanct in that it offers confirmation of the constitutional independence of the constable who is answerable to the law alone. This position is singular to policing in England and Wales and is still regarded by most observers as being worthy of protection. And then you can see further recitation of the argument, but at 4.2.7, the Taylor conclusions, having considered these points, there is a case that it's not in the public interest for Parliament to abrogate its responsibility to regulate policing in favour of the market forces of normal employment law. Seeking to keep a simple framework of regulation, the following points are central. The point is often missed that policing is too important for the general well-being of society to allow the management of conduct issues to be left to employment legislation. The role of the state government in pursuit of the safety and scrutiny of the citizen demands a higher level of control over the policing environment, extending to providing a specific framework in which police officers can be held accountable. The existence of the IPCC is testament to that philosophy. There's then in the next bullet point, police officers like the military can exercise lethal force, occupy a special position and authority that requires control through Parliament. They go into the next bullet point, they go into dangerous life-threatening situations. Next point, it's not a convincing argument that simply because the employment law window has been opened in a number of narrow but important areas, and of course we're debating how widely it's been opened in the present case, that employment law as a whole should be embraced to cover all police activities. Supporters need to show what value that would add. There's then recorded in the next bullet point, going to Lord Hughes's questions, there is an element of this, of course, which is advocated by those who represent police officers, because the procedures do actually provide greater protection than the typical employment disciplinary procedure. And one of the key concerns was to retain the right to legal representation, which in the normal regime you wouldn't have. And of course, the applicability of a general appeal tribunal as opposed to a specialised police appeals tribunal. So there are further points made, and there's then at 4.28 a broad conclusion. That conclusion includes the point, which in fairness I draw attention to, that perhaps the differences between the two approaches are not as stark as the warring parties or the arguing parties debate or contend. But in the last sentence, agreement on the need to stay within a regulated system has been a key factor in achieving the consensus for change set out in this review paper. So I do say that the considerations are different in the context of the police disciplinary procedures.
But these arguments might be seen to be making a case for there to be superimposed on conventional employment law a greater degree of control, as evidenced by police regulatory provisions. In other words, it doesn't necessarily exclude the access to employment law, but because of the nature of the policing operations, that there needs to be yet a further level of regulation and discipline.
Well, in my submission, those passages show that there was essentially a consensus in the course of the Taylor Review that a distinct approach to questions of disciplinary action in relation to police officers was required because there were wider considerations.
But it is one thing, isn't it? Perfectly understandable thing to say that the precise disciplinary framework within which police forces have to operate should be decided upon and prescribed by Parliament.
Yes.
For all of these reasons.
Yes.
And that therefore, simply leaving it to unfair dismissal law, which basically does impose upon employers a degree of due process, but it is very variable and tends to vary from employment to employment, is not good enough.
Yes.
It doesn't tell us anything very much about the applicability of non-discrimination law to those processes. Is there anything in the Taylor report that tells us anything about that?
Well,
I feel sure if there was, somebody would have...
we both have drawn attention to it. Yes, perhaps my fault. The reasons why I drew attention to those passages at this stage in the argument are primarily...
Well, they're good things to draw our attention to, yes.
Because because they go to the question of judicial proceedings immunity, which is the first issue. My lady, you in particular, in the course of Ms Monaghan's submissions, expressed no doubt the provisional view that, in fact, the SIs were really no different to any other disciplinary procedure. And I'll come back to that point in due course. I don't think
that's what I said. I hope it isn't. What I said was it was more comparable to that than to other processes.
I overstated, I apologise. But I'm really getting at that point, and what I'm identifying is that the process of consideration leading to the 2008 regulations included a recognition that there were distinct considerations in the case of police officers, and I will submit in due course that supports the argument for judicial proceedings immunity. I'm not simply saying these are procedures which are enshrined in statutory instrument, but I do say that's important. I'm also saying that when one considers those procedures in context, one sees in my submission that judicial proceedings immunity does apply, and it's not surprising that that's the conclusion that was reached by the Court of Appeal in Heath. Fourth theme, sorry, there's rather a longer theme than mine. Fourth theme is obviously anomalies featuring in both cases. Lots of anomalies identified against our case. My broad response to that is, firstly, the position is not as stark as it is represented on the other side. Secondly, that what is really being referred to by reliance on anomalies is a set of decisions advisedly taken by Parliament for the reasons that we've just been looking at in the Taylor Review, to deal with different cases differently. So that if you have a case where the issue is removal of office as a constable, that is dealt with differently to a situation where that is not what's being proposed. In that case, you have a misconduct meeting. And the statutory instruments, yes, do distinguish between different ranks of police officer. And they do distinguish, for example, between the approach Parliament has adopted does distinguish between probationary constables and cadets. Probationary constables do not have tenure until they've reached 2 years' service. The chief officer is able to decide, therefore, to terminate, to dismiss them without needing to seek the approval of a disciplinary panel. And in the case of cadets, there are different arrangements altogether. All of that's accepted, but those are decisions that Parliament's made to deal with those cases differently, and to afford greater or lesser degrees of protection according to level of tenure and or seniority and or what sanction is proposed to be imposed. Fifth theme, in my submission, the elephant in the room in relation to the sets of arguments put forward by both the appellant and the Commission is the fact that the Equality Act, Section 42, was enacted against the background of the decision in Heath and the decision in Lake in the Court of Appeal. In the context of a number of visits to the legislation, both the statutory instruments and the equality legislation, and yet in my submission, it's clear that Parliament did not seek to reverse those decisions. And that, in my submission, is a very important feature of the debate. What this court needs to grapple with is the question, why is there no sign at all? It's not even suggested by the other side that the Equality Act was intended to overturn Heath. Those are my preliminary observations. If I can turn then to issue one. Before, what I propose to do is look at, I think, four or five of the cases with the court, and then to apply those cases in the context of the 2008 regime, and then deal with some of the arguments that are put against me. But before I do that, can I again make two general observations? The first is that no doubt because of pressure of time, there was, with great respect to Ms Monaghan, a tendency in her submissions on the subject, on issue one, is there judicial proceedings immunity in relation to the proceedings of the panels, to elide that question with the question in issue two, which is, if there is judicial proceedings immunity, has that been displaced by the Equality Act? It appeared that she was submitting that there shouldn't be judicial proceedings immunity, in principle at least, because the claim in the present case was a discrimination claim, and I fully accept that the fact that the claim is a discrimination claim is relevant to issue two, the interpretation of the Equality Act, and the European law issues. But the point that I'm making is that the question, did judicial proceedings immunity apply to the proceedings of the panel, is a question of general application. Ms Monaghan wasn't submitting, or at least I didn't understand her to be submitting, that judicial proceedings immunity doesn't apply to discrimination claims unless she's right on issues 2 to 4. So clearly from the point of view of the decision of the decision of this court, that if this were its decision, that there are no judicial proceedings immunity, would mean that there could be any manner of claims brought against the individual members of the panels. And it's on that footing that in my respectful submission you need to address the first issue. You need in my submission to ask what are the general principles of the common law in terms of identifying whether there is judicial proceedings immunity, and then to apply those principles to the fact of the present case, before going on in issue 2 to ask, well, if there is judicial proceedings immunity, is the position different in discrimination claims?
When you say any manner of claims, I mean,
Yes.
let's just have a few instances. Defamation claims, it would undoubtedly be a situation of qualified privilege, wouldn't it?
Sure. But,
Can we think of any other obvious examples?
well, it's not always, the concern is not always that sound claims would be brought. I mean, one can imagine the disappointed individual in relation to a panel decision wishing to allege all sorts of things. One sees, for example, in employment tribunals frequently alleged negligence. And you then have the process of getting the claim struck out on the grounds that there isn't jurisdiction and so on. But my point is not, I'm not running a floodgates type of argument.
It sounded a bit, that's why I was challenging you.
I'm so sorry, yeah. No, not at all, and it's my fault for not making my position clear. All I'm submitting is that the issue 1 question is a general question which doesn't fall, there was talk of balancing competing public interests. The competing public interests are as between no ability to establish liability for any claim on the individual members of the panel, and conversely an ability to sue 1, 2, 3 or all of them.
Well, that was why I was asking Miss Monaghan, because the public interests that were being identified in the quotation she showed to us were those for witness immunity rather than for judging immunity.
Yeah. But she isn't arguing on issue 1 that judicial proceedings immunity doesn't apply to discrimination claims. That was argued by Ms Booth in Heath, didn't find favour with the court, and she's not resurrecting that argument. Nor, as I understand it, is she arguing that whilst the witnesses might have protection, the members of the panel would not.
It is relevant to the general point.
Yes.
Is relevant to what are the public policy
Yes.
concerns here.
Yes.
One can readily identify them in relation to witnesses. They're slightly less easy to identify in relation to the people, the decision makers. They are there. I'm not suggesting there aren't any. Quite the reverse. I just want to tease out what they should be.
Yeah, I follow. I am going to come to the rationale, but I'm happy to deal with that point. That in my submission,
Don't let me interrupt you.
Well, in my submission, there are no, not. I'm very happy to deal with the points that concern the court. Let's try to. In my submission, there are the policy concerns are rather similar in the sense that both for witnesses and the members of the panel, in my submission, public policy ought to discourage a multiplicity of actions. But also, secondly, that public policy ought to encourage, for example, in the case of witnesses to do their duties. I think my lady put it in the Jones and Caney case, that they should feel free to raise the issues that they wish to raise without a concern about being sued for doing so, lest they be reluctant to come forward, claim, etc.
Well, I mean, of course, the same consideration applies where there's no adjudicative body, but simply an employer receiving a complaint, and the employer investigates the complaint and takes action. If in that situation, there may well be persons who provide evidence to the employer, whether in writing or orally, but it's settled law. They are protected by qualified privilege. I mean, why should somebody receive an absolute? I mean, in the law is you get qualified privilege if you're in that situation because of the public interest in your saying what you have to say, reporting a matter of concern. But unless it's an adjudicative body, you don't have absolute immunity.
Yes. But that's why my contention has to be that it's a quasi-judicial body. Yeah.
Well, I mean, I'm wondering if this argument really doesn't, if it really goes anywhere.
Well, The question, is there judicial proceedings immunity or not in a given case, in my submission, it involves asking, is there a sufficient degree of similarity with judicial proceedings?
But if it involves balancing the policy considerations, which we've been told it does, it's quite interesting to look at what those policy considerations are
Yes, I
in this
understand.
particular
I
context.
understand.
I think my lord and I are putting the same point to you in
Yes.
a different way. Yeah.
Well, my answer is, as given, that in the case of there's a multiplicity of proceedings considerations, and as in respect to witnesses, both witnesses and decisions and panel member decisions, in my submission, they should be free to. It's a question of freedom of expression in the sense of freedom to say what needs to be said in the case, but also to decide what needs to be decided.
I think the multiplicity of actions point is really more a collateral attack point, isn't it?
Mm-hmm.
What, can I ask Melody what lies behind I'm inclined to accept that point, but what?
Yeah, so well, if you want to think about it a bit more, multiplicity of actions, it's by no means rare for there to be more than one remedy
Yes.
to deal with different aspects of the same factual situation.
Yes.
That is not rare at all.
Yes.
And so multiplicity of actions doesn't, in a sense, come into it. It's just horses for courses. But there is the point that if you've had a process of a particular character, it is, of a judicial character, it is not subject to collateral attack. And you can't bring different proceedings to try and get at the same result that you wanted by a different route. Now, my suspicion was that that's what you meant by multiplicity.
Melody's absolutely right. That is what I meant. It's my defective terminology, but that is what I meant, yes.
Yeah.
I mean, one of the arguments, I forget which judge it is who said this, but there's somebody who said in one of the authorities that nobody but a fool would be a judge unless there was absolute immunity. And nobody compels you to be a judge. You know, people have to be recruited to act as judges and arbitrators and so forth. They're all volunteers.
Yes.
The argument is that it would be lunatic to volunteer unless you had this protection. On the other hand, an employer has to run his business. He has to take decisions whether to dismiss people for misconduct or not, or he may have an HR department which carries out inquiries and takes these decisions on behalf of the company. But one way or another, these people aren't volunteers. It's their job to do this.
Yes.
So why do they require, why is there the same imperative to give them the degree of protection which somebody who is properly carrying out a judicial function has to have?
Well, I'll reflect on that overnight, because I might say it's obviously a good question. But my initial reaction to answer to that is that because there's a contractual relationship with the individual employees under which they can be required as a matter of contract to perform their functions, by definition they are not independent individuals performing statutory functions under a statutory instrument, nor are they persons who are purporting to act in the public interest and or hold police constables accountable.
Well, aren't members of the panel we are dealing with compellable to do this as part of their duties as police officers or HR staff of the police authority?
I'll consider that overnight, if I may. May we turn to Trapp and Mackie?
Yes.
That's in volume A2, tab 23, 597. If I may, I'll just highlight, you've already had a look at the judgment, the decision of the House of Lords. You can see in 599 at the top of the page, I don't read it to you, statements of the long-standing nature of the doctrine. At C, a passage which I've mentioned, on 599, the question is whether the tribunal has similar attributes to a court of justice or acts in a manner similar to that in which the courts act. And this is not intended to be disjunctive. You can see statements of the rationale against F. I don't repeat those. And you can see against at 599 the test. Can I pause at the bottom of 599 in relation to recognised by law and begin addressing my learned friend Ms Monaghan's argument about recognised by law, and essentially saying that, well, it's really no different to a contractual procedure, see Christou. There you see the statement that the doctrine doesn't apply to purely domestic tribunals, although not necessarily confined to tribunals constituted by an act of Parliament. Then I know you've looked at the passage, so I don't repeat it, but you can see the statutory provisions that were in place. Section 81, under subsection 3, the process to which the question arose, in respect to which the question arose, does judicial proceedings immunity apply, was a Secretary of State making such inquiry as he thought fit. So broad procedural freedom, but at 600, typically the inquiry carried out by way of local inquiry. And you can see at the bottom of 600 a wide discretion to the procedure to be adopted. Now, what Lord Diplock then records at 601 below D is that Mr. Kisson QC, who was carrying out the inquiry, in fact chose to adopt a procedure that was very similar to a court procedure. And the powers, for example, for evidence to be given on oath were noted at D. If I can ask you then to turn over to page 602. In relation to my learned friend's submission, that, well, the decisions of the panel are not binding, you can see that you've seen already that that was the case indeed in Trapp and Mackie, that the decision of Mr. Kisson in the inquiry didn't bind the Secretary of State. But what was said is you have to look at the practical realities, and between B and C, it would take a bold Secretary of State to overrule a legally qualified commissioner who he himself had selected for appointment. And obviously looking ahead to the arguments about the situations in which the chief officer himself doesn't make the decision but receives a report. There's further discussion of that at page 602, just above F. It was said not to matter if in strict law there was no binding effect for the commissioner, if in practical terms it was highly likely the Secretary of State would adopt it. That was sufficient for the decision of the inquiry to be binding. And just below G, the Dawkins case that I want to come back to, it'll be tomorrow, was referred to. A military court of inquiry with which that case was concerned was a tribunal of this kind. It reported its opinion to the Commander-in-Chief, in whom the decision-making power was vested, and I'll come back to that in due course. At 603 below B, you can see the Lord Diplock stating that just above C, that legal technicalities have at most a minor part to play, where the report of a tribunal, though not necessarily decisive as a matter of legal theory, nevertheless in practice has a major influence on the final decision. That in law is binding and authoritative. There's then recitation of the features in Trapp and Mackie which led to the conclusion that judicial proceedings immunity applied, and I accept that as Ms Monaghan has submitted, there were features of the arrangements in that case which are absent in the present case, and which led their lordships to reach the conclusion they reached in Trapp and Mackie. But what I draw attention to is, against 604, that Lord Diplock was careful to say that he was not saying that all of those features needed to be present for the test to be passed, or that the absence of any one of these characteristics would be fatal to the existence of such absolute privilege. His conclusion was, against B, that those features are more than enough to justify the contention of the respondent, Mr. Mackey. If we may look then at Lord Fraser's speech, he against at the bottom of 605 deals with the Royal Aquarium case, citing the passage from O'Connor that I've already mentioned. And he then turns to the Dawkins case, and if you have 606, he deals with what was said in the Dawkins case before it reached the House of Lords, that is in the Court of Exchequer, where Chief Baron Kelly said, in relation to a military court of inquiry set up by the Commander-in-Chief in the case of a witness who, being a military man, could be compelled under the Queen's regulations to attend and give evidence, that under the regulations, officers in the army, if competent, if required by competent military authority to attend, are compellable to attend and give evidence. There's therefore no sound reason or principle upon which such a witness called to give evidence in such a court should not be entitled to the same protection and immunity as any other witness in any other courts of law, equity in Westminster Hall, is equally compellable to appear and give evidence. So in Dawkins, a key feature from the point of view of the Court of Exchequer, and we'll see in a moment tomorrow in the House of Lords, was the compellability of witnesses. And I'll be drawing attention to the fact in due course that under the 2008 regulations, for the first time was introduced a power to compel witnesses to attend, or in particular to compel officers at least to attend. And then in relation to Dawkins, I also rely against 606, again in 606 against E, observations about features that were missing in the Dawkins case. Clearly, compellability was the decisive factor there, and the decision was reached notwithstanding certain factors which might have considered as detracting from the status of the Court of Inquiry. But the Queen's regulations expressly provided a Court of Inquiry is not to be considered in any light as a judicial body. The Court had no power to administer an oath. It sat in private. It could not itself come to a final decision or adjudication on any case. Its function was to report to the Commander-in-Chief, and then against G, any decision would be made by the Commander-in-Chief. And there is then, as you can see against H, further reference to Barrett and Kearns. The final decision was taken not by the Commission, but by the Bishop. And there's an observation at the top of 607 that in Slack and Bath, the absence of power to compel witnesses was not decisive, and there's then reference to Lincoln and Daniels, where there wasn't a power to compel witnesses, but nevertheless, tribunal of benches in one of the Inns of Court was held to be protected by judicial proceedings immunity. My lady, can I then invite you to turn over to 608 and against C, further to the question, is there judicial proceedings immunity if the decision of the panel does not finally determine the issue in a binding way? The way Lord Fraser put it was that absolute privilege may apply if the inquiry is a step leading directly towards determination of an issue by the authority who appointed it. My lady, that was all I wanted to take from Trapp and McKee. Essentially, that it's...
I think it's Mackey.
I'm so sorry, Mackey. I apologise to Lord Fraser. Trapp and Mackey, that it isn't an issue which engages a technical approach. It is one which involves consideration of, as it were, the four themes identified by the House of Lords. It is not a case, not the case that the presence or absence of any particular feature will be decisive. An overall assessment needs to be made. But the overarching question in my submission is whether there is a sufficient degree of similarity to a court of justice, and or whether the body acts in a manner that's similar to the way that courts act. Moment.
It looks very convenient to me. Trouble is that clock differs from this clock,
Right.
differs from this watch. So a certain degree of flexibility has to be expected. Thank you very much indeed. We'll look forward to hearing from you further tomorrow morning. Court is now adjourned.